Virginia kneecaps, the Constitution and the kids. This is ICAC Unpacked for April 8th, 2024, Monday. I want to report today, now that the governor has gotten some of his more egregious violations through his veto pen, I wanted to tell you how Virginia, which started out as a terrific example of bipartisanship and very progressive, and by that I mean small p progressive, meaning that there were far-reaching ideas that were put forth and some great bills. Our governor has decided to drag us backwards more toward the 1950s by kneecapping children and those with intellectual disabilities, those who have dementia, those who have mental illnesses and issues, and elevating the police, which already is a protective class, and gun rights owners to higher, less likely accountability, despite the fact that we have more people who are being killed by guns, more children who are being injured, teachers that are being injured. That was not a concern of the governor, of course. So let me go through a number of really bad ideas and show you the inconsistency that our governor has. So first of all, HB 697, it was a very worthy bill, very progressive, small p progressive, to deal with the use of AI images that one could use to create mischief. So somebody could take a picture of me and voice synthesization, and it would be a fake image and a fake profile, but they would use that, and currently there's no criminal penalty. There would be, at least under this legislation. And the governor decided that he would veto that, so there's zero interest in that. A number of years ago, they created scenarios into the court where wiretapping is completely okay. Anybody can wiretap anybody else. Anybody can fake tap anyone, and in the most intimate, private places, tunnel into their computers, and there's no penalty effectively for that kind of thing. And the police do it, we know, all the time anyway, in violation of our Fourth Amendment. This compounds that because it fails to look at how AI-generated technologies or other synthetic media, as they call it in the bill, can be weaponized against you. No penalty for that. Perfectly okay in Virginia, thanks to our governor. HB 250 allows law enforcement to continue their unethical interrogation practices, including giving false promises, misleading requests, fake documents, and basically people who are of above average intelligence are already at a disadvantage. Can you imagine what the intellectually disabled are put in positions of? More on that in a minute. They are sitting ducks for police and prosecutors. And remember, as somebody said recently on a radio program I listened to, we don't have a justice system. We have a system that plea bargains you to death. And we have a plea bargain system in effect. And that is not the way it's supposed to be. In other words, you're going to get convicted no matter what. So it doesn't matter if you're like me and you're falsely convicted. You're going to get convicted and have a penalty. And you are forced to plead guilty or they will add charges. We have a case in Louisiana that I'm following right now where the man said he would not plead guilty to anything, and they said they would add over 100 new charges because that's what they do. They force you into a plea deal, and then they tell the public, look, we have a 90% or 95 or 99% conviction rate. 250, HB 250 will allow the law enforcement entities to continue to torment people and to go after folks who would, in many cases, be otherwise innocent. Nothing wrong with going after the bad guys, but you have to be fair and you have to be ethical, and they are neither. HB 1255, I think it is 1250 or 1255, limits how long one can keep you on a technical violation. So this happened to me, of course. We have police who, working with the probation officers, have you arrested? I was arrested because I was in a hotel lobby working on my book and looking for jobs with the computer. Why didn't I use my own? Because the police had taken it. And I was told by my probation officer I must have been there to see a child. Speculation on her part, pure speculation. I was arrested for it. They could have held me a long time, except that there was a law that said that it had to come to a easy adjudication. But of course, that happened after some other elements. It was a procedural thing I won't get into, but I was held for weeks. The second time she did it, had me arrested on similar tone, claiming I was in a library doing some kind of mischief, which I was not. And since they log in with your library card number, they could easily check that. Of course, they didn't bother with any of that. I had to pay $500 to get out of jail. So this bill would have limited or eliminated how long they could keep you. They would have to adjudicate you within 2 weeks. The governor vetoed that, so now they can hold you as long as they want. The vast majority of people held in jails today are there because they're waiting for trial, they're pre-trial non-release, or they don't have money for the bail. HB 45, no early release for earned sentence credits. There are a variety of ways that you're allegedly leased on the books, able to get earned sentence credits. You can do a combination of good behavior, taking classes, etc. But it's at the sole discretion of the Department of Corrections or the jail whether they want to honor that. This is what they told me when I was in jail. It's not the official word necessarily, but it's how things actually works. The governor vetoed the requirement that they would have to give earned sentence credits and have a consistent program and monitor for that. HB 267 says that there is no break. This is the worst one. No breaks for so-called assault on law enforcement. You understand, if you bump up against somebody, it's assault. So if you have somebody who is mentally ill, high, suffering from dementia or autism, or having an undisclosed illness where at some point the police say that they were assaulted, and we know that police say that all the time, it's an additional charge that they can add on to their assaulting a police officer. You move this way and you accidentally hit somebody with an elbow, now you have an assault charge. And yes, of course, do people really lash out? Sure. But this is the most vulnerable population. The governor decided they didn't need the protection. Law enforcement, in his explanation, law enforcement needed more protection. So HB 267, he vetoes protections for the most vulnerable. He vetoed, of course, HB 1, the minimum wage, because, of course, people don't have to have a living wage. And he vetoed SB 80, decreasing time on probation, that there would be no way that you would have a maximum cap on your probation. Even though there's no evidence that lengthy probations do anything for anyone. No evidence at all for it. In fact, all it does is kneecap you out in the general public and make it that much harder for you to get and maintain a job. And then, of course, probation can punish you for not having a job that they, in turn, helped destroy for you. So this is another ridiculous bill. Veto of SB Senate Bill 80, decreasing time on probation. SB 327, well, there should be no age limits for getting a gun. So if you want to get one at 18, that's perfectly fine. The governor vetoed any kind of age limits, 21 and over, even though there's plenty of evidence that an older person having a weapon or being able to drink alcohol or whatever is actually a better thing than a younger person. SB 351. Well, the governor decided we didn't need safety locks on guns in your home if you have a minor child, so that too was vetoed. HB 308. No relief for geriatric inmates. Anybody who is incarcerated in a Virginia prison who is very aged. And remember, plea bargains are the thing, so they are forced to plead guilty even if they're not guilty. And there's a book on this, I can't remember, by a judge, and he says it's an unfair system too. He should know, he was in it for his entire career. But there again, no relief if you're aged. or suffering from any kind of illness inside prison, the governor decided to make it that much harder for you to get a compassionate release. Some bad bills that did not make it out, but that the governor did not veto. He did veto this one, I think. HB 1143 replaces the term child porn with sex abuse materials. This is a favorite of Republicans, and it seems very reasonable. We're going to take the words child pornography, and we're going to replace those with the other words, the better words, which are sexually explicit sex abuse materials. Well, who gets to decide what sex abuse materials are? The police, of course, the police and the prosecution. Child porn has the benefit of everyone knows what it is. It's specific to a particular word, child, and everyone understands what porn is. Deviants out there involving children, which most decent people that I know of would not be in favor of. I say most because, some of these same people who vote against this sort of thing are the ones later caught up in it. So, and they're the decent people. So why would that be a terrible thing? Well, because when you add sex abuse material, it's so vague, it's so broad, they can define it any way they want. In keeping with that, HB 1276 also managed to not pass, and that's a good thing. But this is what they have tried to do for the last several years, put these bills through. You can't display sexually explicit material with the intent to induce or entice a child. Well, this is what it comes down to. Grandma has a picture on her mantle of her two twin boys in a bathtub, toddlers, and they're naked. And she likes showing these cute kids playing with the rubber ducky and everything. Well, some neighbor comes over who's perhaps a new friend or whatever and decides that this is inappropriate and reports her to the police. And all the prosecution has to do is say, well, this has been, this is to induce or entice a child. Okay? So, my child saw this on the mantle and was upset. That's all it takes. It's as bad as if you are peeing in the forest and a child comes by and sees you. All they have to do is see you, and that's a class 6 felony. So these sorts of bills are ripe for abuse. They come out every single year practically, and thank God they get defeated, but they're bad bills. And who knows what this governor would have done if they actually passed. So what's really interesting is that there's no veto for any gun bills. You can have as many guns as you want, no restrictions on them at all. But our most vulnerable population, kids, protecting kids, and protecting the intellectually disabled, the mentally challenged, the sick aged, or the just, people off their meds. No, there's no protection for those. They have the full weight of the law against them. It's such an upside down weird system. It doesn't protect our constitutional rights. It's not scientifically based or time tested in any way. When you look at the research, it doesn't support any of these bills that any of these veto options that the governor has decided to go through at all. And in fact, it makes us less safe. But the crowning achievement on this is SB 6. This was passed by the legislature very, very early on, and the governor didn't see fit to veto it. This says that if you have been convicted of multiple drunk driving incidents, and now you're at the point where your driver's license has been taken away for several years, well, you can petition to get your license back. In fact, you should get your license back because, after all, you have to work. It's really unfair that you should be put in a position where you may, have to go back and take the bus or have somebody drive you. That would be terrible. I was in jail with somebody who had 5 drunk driving convictions. 5. And he was still coming back to jail for 30 to 60 days and trotted right back out there. He did the so-called treatment programs. It didn't work. He admitted he had a problem, but he was unable to stop. At the same time, they're going to let him out again. Okay, he was there twice in the 6 months that I was there. Okay, I think fifth and sixth violation. I know this because I helped him write his responses to the judge because he thought he was finally going to be hammered. This would even weaken that. So let's see. We're not going to protect the public from drunk drivers. Perhaps some of those are people in the legislature, who knows. We're going to make sure we protect those who have guns. We're not going to protect the weakest members of our society, but we are going to hammer people who go before police and prosecutors, because of course that has been so great. Virginia prosecutes and incarcerates more people than any other state, according to the Prison Policy Institute. How well is that working for us? Not at all. So, now we have a situation here where the police basically can do what they want, and there's no reasonable restrictions for them. There was a young man I knew in jail who was 19, and the police told him that if he confessed to crimes he did not commit, they would take him on, they'd arrange for him to get out, they would go and have a hamburger, they could spring him loose, and this young man was smart enough to look at them and say, "That's a lie. You can't get me out of here. That's not how it works." But the police will do nearly everything to get their conviction. And it really doesn't matter. And the public needs to wake up to the fact that this gross inconsistency is still out there. One final word that I have to mention again regarding the so-called sex offenders. So here there's been multiple bills, much less this year, hammering people who have so-called offenses, whether they did it or they did not. But yet we have people like Caitlin Grimley and a lot of women out there who have a different standard. Somehow their standard is completely different and they get away with it. And there's no effective penalty. They can go to something called restorative justice and get a break and go right back into teaching or right back into doing whatever they're doing. And yet this is not available for anyone else. And if you're on the sex offender registry, for example, which would ordinarily be the result, whether you're on for somebody like me, who didn't do anything, but was convicted of computer solicitation, we thought you might do something because we put a minor persona in front of you and you kept talking to the person, even though there was no sex talk. We thought you might possibly do something, not you were trying to protect the person or nothing like that. They didn't care about that. You're on the sex offender registry just as if you had done some horrible thing against a toddler or raped a woman or something or sodomized and then killed somebody. It's all the same as far as the registry is concerned. There's no concern about that, but yet if you're a drunk driver, there's a concern. If you own a gun, there's a concern. If you're a police officer, there's no end of compassion for those people. So it's really pretty remarkable. This is ICAC Unpacked. I'm Norman Michael Asian.